Okay, so let us work together because at least together we are stronger. Hello. So if only my computer will also work together with me. Okay, so here are our outcomes. We have looked over the past couple of weeks at what is the education law, how does the legal system work, how does the legal system and the education system interact with one another. We have looked at the typical concepts we use in education law. We have looked at the sources of law. We learned how to identify legal issues and how to formulate legal questions, and also how to answer legal questions by interpreting legislation citing from the law. Today, we are going to use those very skills and we are going to go a little bit deeper, and we are looking at a scenario where we are going to use our 6 bricks to address a specific scenario, which is a little bit more complex, where we don't just cite one section or provision, we will cite multiple sections or provisions to answer a specific question or to address a specific scenario. Okay, so let us jump into it. I'm just going to quickly recap, because the more often we repeat something, the easier it becomes for us to remember them. Also, I want to say that often what I've seen in some of your answers during class in the chats, also the other, I'm now talking about all the students, the entire 1,400, not just distance. All the students, often you leave out some of the steps. So be sure to include all the steps when, especially for assessments. In real life, you will get into situations where you need to make a point, make a recommendation, support or defend yourself or your own position, or defend your own behavior or conduct or decisions. You might be required to write a plan or plan for an event at school, or maybe you are involved in drafting safety plans, or you might be involved in disciplinary committee work. There's a lot of situations as a teacher in school where you need to rely on the law and where you will need to make a legal argument. So it is important that you always include your evidence so that you can convince people, because if you don't give evidence, you won't be able to convince them. And if you don't convince them, you will lose the fight, if it's a fight. It's not always a fight, but if we are taking a position, often it's a conflict situation, or often there are differences. And if you want to win the debate, you need to be able to make a very good, clear argument with ample evidence to support your point. Okay, so that's what we are doing today. So let's just recap. We always need to have a reference to the source. So what sources are we using in education law? We can use the sources of original legislation. We can use the sources of subordinate legislation. We can look at national policy. We can look at case law, court cases, or we can look at other legal principles. We have to have a reference, just like if you write an essay or do a speech and you say, this is my point, and I'm going to convince you of my point in point 1, point 2, point 3, you have your references to your academic sources. Usually in law, we use legal sources. So you have your reference, which includes the red block, the name of your document, the orange block, the document identifier, that is the document's number and date. So this one, the short title of an act for original legislation, is quite straightforward. South African Schools Act 84 of 1996, Employment of Educators Act 76 of 1998. When we get to subordinate legislation, the orange block looks a little bit different. Your title might be longer also. You would have the regulations for safety measures at public schools, which is a bit longer. And then your orange block will now be a government notice number, a government gazette number, and a date. And then our yellow block always stays the same, the section number. Please remember that you need to cite proper subsections. So if you are referencing a little part of an entire section, I mean, most sections have 3, 4, 5, 6, 7, 8, 9, 10 subsections. Don't just say section 9. Section 9 is 3 pages long. Tell the reader or the listener what part of section 9, section 9 subsection 1C, or section 9 subsection 1, or whatever. So use a subsection number when you refer to only a little part. Don't cite the entire section unless the entire section is relevant to your answer. Okay, so that is our reference. Then we must have a quote. We must tell the listener or the reader, what does it say? This is where the law says it. This is what does the law say. So your reader or your listener must know, what does the law say and where does the law say it? That's your reference and your quote. Now, also, you must explain in your own words, not in the words of AI, ChatGPT, Copilot, whoever, not in the words of copying directly from a textbook, a book, an article, or whatever, in your own words. The only way, if we mark your work, the only way for us to know that you understand what the law says is if we can see that you are able to explain it in your own words. Okay, so explaining your own words, the interpretation, what does it mean? There's also something else I want to say about the blue block, the interpretation. The interpretation, sometimes students will ask, but how do I know what to write? So the interpretation of law is informed by legal theory. Legal theory developed over millennia. Legal theory tells us what we understand with certain legal concepts, certain legal rules, certain words used in the law, certain principles. Okay, and all of that, not all of that, no, the basic legal knowledge that you must have as a teacher is in your textbook, Introduction to Education Law. So it's extremely important that you take the textbook, you work through it from page 1 up until page 236. All the pages, go through it, make your summaries, make sure that you understand what's going on. If you find concepts in the book, make a list, keep a list of concepts, core concepts, so that you have a list and you know, when you interpret the law, your dark blue block, that you know, oh, equality. Oh, yes, I know in the legal theory there are two types of equality. There's formal equality, there's substantive equality. This is what formal equality means. This is when it applies. This is what substantive equality means. This is when it applies. Oh, I know when I read Section 9 in the Schools Act about suspension and expulsion, I know that there are two different meanings. Suspension is temporary and expulsion is permanent. I also know that it's the SGB that suspends and the HOD that expels. If I read about a certain type of punishment, oh, I know the definition of corporal punishment and I'm able to evaluate whether such punishment is corporal punishment or not, and whether or not it is allowed. So it's important to know your legal theory. And then also with the interpretation, not only legal theory is important, but also the definitions, which you find in section 1 of your act or your regulations, whatever the case might be. So remember the definitions, we have looked at those, we've worked with them last week and the week before. So we also use definitions to help us interpret. We can also use case law that we typically do in postgraduate studies. We don't expect a teacher to work with case law, but if you do follow an education law postgraduate, you will typically also use case law to interpret. Hello, do you have a question?
My only problem.
Okay. All right. So with your interpretation, legal theory, case law, the definitions in the Act. Okay. So that is your dark blue block. And then we go to the application. Before we get there, let us just quickly look at your citations for the sections and the subsections. So again, be mindful that we do not cite our main section. So I'm going to call it level 1. Our main section, the main paragraph, we do not use brackets for that one. That one does not have brackets. So we will say section 14 without brackets. And you will see even if we add subsections, the 14 remains out of brackets. It's the level 1, the one that has the heading, doesn't get brackets. And then if we have subsections and subsections and subsections, remember each one, I will call them levels. So if we have level 1, level 2, level 3, level 4, then level 1 will be subsection 1 of section 14 is 14 bracket 1 close bracket. And then subsection D, which is under subsection 1, we will write 14 bracket 1 close bracket, new bracket, D close bracket. Also be careful if you write a D or an A or a what, if the act or the regulations or whatever uses a capital letter, you use a capital letter. If the act uses a small letter, you use a small letter. And then if we have level 4, which is a subsection, we have section 14, bracket 1, close bracket, bracket D, close bracket, bracket Roman 1, close bracket. Okay, so remember to use your brackets correctly to distinguish the different levels. If 2 or 3 sections you quote are on the same level, we separate them with the words and, or a semicolon, or the word to, or the symbol and. So long as you separate them if they're on the same level. If they are on different levels, we write them like this on the screen, next to one another, brackets, close to one another, no spaces or commas or something in between. Okay, remember not to separate the parents and the babies. And remember to follow cross references because that helps us to understand the family as a unit, and check your punctuation. Okay, and that then brings us to our last block, the green block, which is our application. Application helps us when we have a specific scenario or situation and we need to apply what the law says, what it means to a specific situation, or it can also be that you give an example to illustrate how or what are the implications of a section that you are discussing for practice. Okay, and we will do one of those examples each next. So then we have all 6 of our steps together. If you do an assessment or if you write exam, please just write down somewhere 1, 2, 3, 4, 5, 6. You know you need 6 steps or 6 components or aspects or elements in your answer. And as you write them down, tick them off to ensure that you have all 6 so that you don't leave out 1 or 2 steps and then you lose marks unnecessarily. Not necessary to lose the marks because you know what to do. You just have to keep track of whether or not you have all of the aspects. Okay, we had these questions the week before, and I placed them in the homework activity on eFundi with some example answers, which you could use to just self-assess your own answers. If there's a difference between my answer and your answer and you don't understand why, please send me a message so that I can help you and assist you if something is unclear for you. At the end of last week, we ended off the session with a few questions that I wanted you to answer from subordinate legislation. So I'm going to look at 2 of those answers now together with you, and then we are going to continue with a scenario which we're going to answer with a little essay. Okay, just a reminder again of how to cite the different documents. We did this last week. I just put the slide for you in again. And then, excuse me, we're going to do the first 2 questions, or two of those questions. Okay, so the first one is from the safety regulations. Let me just quickly check. I see there's something going on in the chat. Let me just double check there. Updated. Has anyone received prescribed textbook? Okay, no, the registration has been extended until Friday, which means only after Friday and the registrations has closed will the books be distributed. So sorry about that, but we will handle it as best as we can up until then. Hopefully within the next 2 weeks, you will receive your books, those of you who are still supposed to receive it. If you're not supposed to receive it, please just buy the book. You can order it directly online, and I did include the link to the Van Skyke online bookstore in the announcements. Okay, back to our question. This question says, with the safety regulations, so you have to have some knowledge to know the safety regulations refers to the regulations for safety measures at public schools so that you can go to the correct document. With the safety regulations, regard a hammer to be a dangerous object. Okay, this is my question. So I need to go to the safety regulations. Just quickly open that. Safety regulations. And when I cite my safety regulations using my referencing, I will include the name, my red block, regulations for safety measures at public schools. And then in my orange block, I will include the government gazette, the government notice number, the government gazette number, and the dates. And then I need a section. Okay, what section will I include? I will look for anything about a dangerous object. So obviously, if you work on the computer, you can just press Control F for find, and you can say dangerous. And I see there are 14 matches. Let's put object, then there are 10 matches. So let us look at them. We have a definition of dangerous object. We have all public schools are declared drug-free and dangerous object-free zones. No person may allow, may possess. Search and seizures, Okay, so basically it's a lot of repetition of different dangerous objects in one section and what to do and what not to do about it. Okay, I want to know whether a hammer is a dangerous object. So most probably the definitions will be my first stop to see if I can find my answer here. If I can find my answer here, I'm happy. If I don't, I will search further on. Okay, so if I read the definition of a dangerous object, you will see that it says dangerous object means, and it has A, B, C, D, and then it has a little part at the end, unless such objects are used for education purposes. So this reads like follows. Dangerous object means any explosive material or device, unless such objects are used for education purposes. Firearm or gas weapon, article or object or instrument which may be employed to cause bodily harm for a person, to render the person temporarily paralyzed or unconscious, or to cause damage to the property, or any object that the minister will add to the list in the government gazette, unless such objects are used for education purposes. Okay, so in this case, let me just get back to my PowerPoint. I think I can use this section for my answer, and therefore I am going to just go ahead and cite section 1. So my yellow block will be section 1. Now I'm going to quote. So you would see that B and A and B and D is not relevant to our answer. So I only cited the C part. So I said section 1 of the regulation. Dangerous object means any article, object, or instrument which may be employed to cause bodily harm to a person or to render a person temporarily paralyzed or unconscious or to cause damage to property, unless such objects are used for education purposes. That is my quote. Now you will see that I have separated or alternated a little bit of interpretation, a little bit of application, again, a little bit of interpretation, a little bit of application. So in this case, I started by explaining, first of all, the first section, which we found in C up until here. And there I explained this means that objects that could be used by a person to hurt another person, for example, by hitting or stabbing or throwing them with it, can be regarded as a dangerous object. That is my dark blue, my interpretation in my own words. Then I give a little bit of application because I've now explained the first part. I want to apply the first part before I move on to the next part. It's also fine if you do the entire part's interpretation and then the entire part's application, that's also fine. It doesn't really make that big of a difference. I just thought that doing it this way would make sense for me. Okay, so within this definition, a hammer can be used to harm someone or may even, when used violently, cause them to lose consciousness. So I'm matching the words in my quote with the interpretation and the application, which is specifically a hammer. Then I come back with another interpretation of the last part that says, unless such objects are used for education purposes. Now I'm saying the regulation, however, this does not automatically render a hammer a dangerous object. The regulations also add, unless such objects are used for education purposes, which means that objects that might be used to cause harm to someone is only considered dangerous when it is not used during the teaching and learning process or in any other task that directly enable a conducive teaching environment. And then I give the application of this little section. We can conclude a hammer might be, I don't say it definitely is. I also do not say it is not. Why? My question did not give me detail. My question did not tell me whether or not this hammer in my question is used for education or not. So I need to consider both possibilities. It's possible that it is, it's possible that it's not, and whether or not it's a dangerous object depends on whether or not it's used for education purposes. So we can conclude a hammer might be considered a dangerous object if the person brought it to school without it being approved for use in education-related activities. Okay, so do you see that the less detail I have in my question or my scenario, the more options I have to almost make assumptions. It could be, it could not be. I cannot give a definite explanation. Why is this important? Because further on in my regulations, we saw that there are certain things we can do. It says that there may not be dangerous objects at schools, but what if it's for education purposes? Then it's not a dangerous object according to the definition, so then it may be at school. No person may allow, and then of course we may do a search and seizure of dangerous objects. So if the hammer is used for education purposes, it's not considered a dangerous object. We may not search and take it away. Whereas if it's not used for education purposes, we may search and take it away from whomever brought it to school, depending on whether or not it fits into the definition. So do you see how the definition is actually important for us to know what we may or may not do in this case? Otherwise, if the hammer is there for education purposes and we seize it, we take it away from the person, then we have taken it away illegally and we are violating their right to privacy. Okay. Let us then go on to the next one, which is the question on the Code of Professional Ethics. Names 3 professional expectations for teachers' conduct towards their colleagues. Give an example of each. And here, I have just done one example because we follow the same pattern, whether it's 1 or 3 or 7. I just want to go to the Code of Conduct. Please be aware that some of you might have this printed out bundle of legislation. The Code of Ethics that is in this one is outdated. So just go to the SAIS website and make sure you have the newest one. So this one I downloaded recently from the SAIS website and it is dated as 2021, September. And if we, in the legislation, if there's an amendment, if there's a change, then it would be, there was a section 9, then a section 10, then they inserted one in between and they would call it 9A. But SAIS does not do it. And also the SAIS document is different. The Code of Professional Ethics is different because it's not published in the Government Gazette like the regulations and the national policy. It is published by SAIS and you can find it on their website. They update it, change it every so often. So throughout your career, you will have to go back to the website occasionally, maybe every 3, 4, 5 years to check and download the newest version. If they make a change, they add new little sections in between. They do not, like the legislation, put a different A or a B or a C. They bump all of the remaining sections onward. So if there was up to 9 and now they have inserted more, they just keep the numbers in plain sequence. So all the numbers after the new section they've added will change. So therefore, it's important to make sure you are working with the most recent document, because otherwise there will be a difference between what you reference and what is actually in the newest version of the document. Okay, that's it. We are required in our question to name expectations towards colleagues. So we are going to our professional code and we are looking for the section that relates to our conduct towards our colleagues. And then you can choose any. There are 7. You can choose any 3 because we are required in the question to name 3 examples. We'll choose one example. I chose this one: refrain from undermining the status and authority of his or her colleagues. It starts here, an educator. It's paragraph 6. And do you see that 6.1, 6.2, 6.2, and so on? It's different from the legislation where we have sections and subsections and subsections. It's just 6.1, 6.2, 6.3, and that is exactly how we reference it. So you will write 6.1, 6.2, no brackets, just the 6.1 and a 6.2. Okay, let's go to the answer. So there, I said, according to paragraph 6, I put the paragraph 6 at the top because I'm then following it up with a 6.1, 6.2, 6.3. But it's also okay not to put it at the top and just repeat it every time before your little subsection. I said, according to paragraph 6 of the SAIS Code of Professional Ethics, and here it's not published in the Government Gazette, so I don't need Government Gazette numbers. I just say SAIS 2021, which is the version that I have worked with. An educator refrains from undermining the status and authority of his or her colleagues. So there you have my first 4 blocks. Then I give my interpretation in my own words. This means that it is unprofessional for a teacher to act in a way that makes another teacher look bad, lose respect, or struggle to do their job properly. And then I give my application, which in this case, in this question, was an example. So I gave a number of examples there: criticizing your colleague in front of learners, contradicting their disciplinary actions, encouraging learners to challenge their authority. Those would be an example. You only need to name one. I just included a couple. And then you repeat the same process for any of the other little sections under paragraph 6. M. Brandon, you are welcome to ask your question.
I just want to know when you have to insert the quote, shouldn't the quote be in brackets, like quotation marks? Because it's not your words.
It can be, but normally in the law, it's not so much required because it's usually implied. If you properly reference it, it's usually implied. But yes, typically and technically you are correct. We would use, if we publish, we would use quotation marks, or if it's a longer quote, we would put it with an indented little section without quotation marks. Okay. But for the sake of your module, it's not that big of a deal.
Okay, thank you.
You are welcome. And then I see another hand, but I can't see your name.
It's Chantal, ma'am.
Oh, Chantal, thank you. You can go ahead.
Okay, I just want to quickly ask, so the subordinate legislations, like these ones, they don't have a section and the little hockeys and everything else. We just put the name and a paragraph. Is that right?
Well, not all of them. Our subordinate legislation usually have sections and subsections, but some documents, like the SAIS Code of Professional Ethics, it's not technically subordinate legislation, although it does have enforcement power. So yeah, it's almost like a special category of its own. And then there are also like guidelines. For example, the guidelines for Code of Conduct for Learners. That one is also the same as the Code of Conduct. It has 3.1, 3.2, 3.3. That one does have some subsections as well. But your regulations and your norms and standards, those all have the same layout as your acts. So it's just the code of ethics and your guidelines that look different. So
Okay,
whatever
why do
you
we call
choose,
it paragraphs? Can we not call it section 6?
we can,
Does it have to be
absolutely.
Okay, so we can.
Doesn't matter. Yeah, you can call it item, you can call it paragraph, you can call it section. Nothing of those will be incorrect. They will all be fine.
Guys, I think it's just for us to try and keep our minds, because it's obviously not something we work with every day. So I think to
Yes.
try and minimize or streamline it, I specifically like to keep to the same words for all of them so that it kind of makes sense to me. And like Marna said
Yeah.
earlier on, I also like to put the quotation because then I know that is my quote.
Yeah.
Otherwise, you sometimes don't know where the quote is, where
Yeah.
the application starts, and it just becomes a little bit blurred.
Yeah, I think that's a good practice, whatever works for you, because obviously it must make sense to you because you are the person who's learning it.
Okay, thank you very much, ma'am.
You are welcome. Okay, so if there are no other questions, we can go on. I'm now going to look at the legal reasoning. So we are doing legal research when we look for sources of law, legislation, court cases, subordinate legislation, to answer our legal questions. Also, when we look for academic sources that explain the legal theory or the meaning of words, the definitions of words that can help us do a proper interpretation. So in your assessments, assessment B and C, you will be required to do legal research. In real life, sometimes you are required to do legal research, other times not. Often when you have a position, you need to defend your position, you will do legal research. And you will defend your position through legal reasoning, which means I'm not defending my position in the normal way with other sources. I'm also not defending it based on how I feel, also, and especially make a mental note. If ever you are in a situation where you have to defend your own decision, sometimes in education, there's a situation where you really have to react very swiftly, and you maybe reacted in a specific in a specific way. Maybe your principal does not agree with how you responded to the situation, and you are on the red carpet and you have to defend yourself. When you have to defend yourself, if you use legal reasoning and you provide your evidence, then it's easy to convince a person of your point. So just also make a mental note of that. It's important to use then legal reasoning. In such a situation, you might feel a lot of emotion. You might be very emotional, you might feel threatened, you might be stressed or whatever. It's important to then bracket that emotion, put it aside, and focus on your legal reasoning so that you can make your point and convince your principal or whoever else of the point that you are making. Okay, so legal reasoning means we rely on the law to support our argument, whereas in a normal argumentative essay or speech, you would support your points with evidence from academic sources. In legal reasoning, we will support our point with reference to the law, as well as interpretations for which we use legal theory, such as your legal textbooks and so on. When you do a legal speech or a legal scenario, you analyze your scenario, you identify the issues, you formulate questions, because the way we ask a question will determine the way or where we go to find the answers or what type of answers we will find. For example, if I ask, did the principal or did the teacher violate the rights of the learners? It's a very different answer than asking the questions, what steps should the teacher take? So that the way we formulate our question also influences how we answer that question. Then we will identify our legal rules. That is when you go to the law and you identify sections, provisions, we call them provisions or legal rules or whatever. Identify the sections or the paragraphs or the provisions that are relevant to your answer. And then you use your steps like the 6 brick steps to cite each of your little rules or provisions or sections, explain them, apply them. And in a scenario, the more complex the scenario is, the more complex this question is, the more of these little sets of quotations and applications and interpretations will you need. And then you might repeat that 2 or 3 or 4 different sections. And then at the end, you will come to a conclusion, or you would bring them all nicely together, logically, in a logical conclusion to say that this was my standpoint, this was my evidence, and this is my conclusion. Okay, so let's put that into practice. I'm giving you the scenario. There is the scenario. The combined school is hosting a festival, cultural festival, and things spiral out of control when a group of learners sneaks alcohol into the premises and starts a fight near the food stalls. An SGB member, furious about the incident, confronts the principal, claiming the school failed to ensure safety and demanding the learners be expelled immediately. The principal calls the learners to the stage, searches their bags, and confiscates the alcohol. The principal further announces that the learners are expelled immediately and that this will be a warning to all learners that the school will follow a zero-tolerance approach when it comes to bad behavior. The principal takes a bottle of saline from the first aid kit, pours it into the learners' mouths, and claims that they need to wash their mouths from the alcohol and learn to never do something like this again. One of the involved learners, a talented performer who is part of the performance program for the cultural festival, argues that they did not drink, but that they might appear drunk because they smoked dacha, which is culturally and religiously acceptable, allowed in their personal background. Therefore, this learner argues they should not be expelled. The principal then allows that learner to remain in the school since they do not want to be disrespectful of the learner's religious and cultural background. Okay, so what I want you to do is I want you to go to the Padlet. I've also placed the link on the WhatsApp. So if you have difficulty scanning, you can just click on the link in the WhatsApp group. It will take you to the Padlet. You need to be signed in. You can sign in with your Google account if you don't already have an account. Excuse me. And then please add a post. So you will analyze the scenario. You will identify a legal question. There are multiple issues. There are multiple questions. You need to address only one for this exercise. And then you put your 6 bricks, your answer. You will see in the Padlet, I have added little subsections for structure for those of you who prefer to work with a structure. If you do not like that, you just use the top little block and you just add your mini essay in that way. Okay, I'm going to set the counter. I'm going to give you 15 minutes. Please analyze the scenario, find 1 or 2 sections that applies to that. Answer the question on the Padlet, and as you do, I will respond to some of the questions or some of the answers in the Padlet, and then just before we end off, I will just quickly run through the sections that I think you could have used. Okay, you can go. Don't cheat and use AI, and don't cheat and read the answers of the other people. You must do your own one. Because this is like learning. Remember, learning to walk the tightrope. The more you practice on your own and individually and independently, the easier it will become. Here, there's a hand raised. Mlamli, you can go ahead and ask your question. Okay, a question. Angie, you can ask.
Good afternoon, good evening. How are you?
Good evening. Good, thank you. And you?
Good, thanks. Dosa, I want to ask if you could please just, maybe this is silly, but my friend and I are really struggling with this whole thing. Are you able to, when you do the answer, can you go step by step? Like, how do you know which legislation to use, which form to go to look in? Just go through everything in detail. Is that possible? Just to do the baby steps again.
Like right now?
No, when we're done. When the time is up.
Okay, yes. Let me just mention that. Remember, your legal knowledge will inform your choices or your the way that you identify issues and answers. So for example, for me, it's easy to know where to go because I have that knowledge, but you are still learning. So the better you know the content of the textbook, the easier it will be for you to identify relevant answers to the specific legal questions you have.
Okay, no, then that's perfect. Because I also, when going through like the activities and I come up with a new question, I'm like, okay, now which one am I going to go and use? Then I look at all of them and I'm like, okay, then I have to go look at the answer first to see if I actually did it right.
Yeah. And if you're working on your own, please don't hesitate to reach out, send me a DM, say, this is the question I have, this is my answer. Do you think it's correct?
Okay, thank you so
Don't,
much. I
don't
appreciate
struggle
it.
on your own because I am here, Moss.
Yes, thank you so much, Doctor.
Okay, you are welcome. Okay, our time is up. I think let me quickly go through the sections that I thought was relevant with you. I'm not going to give the full answer. I'm just going to mention the sections, and then I will respond with more detailed feedback on your answers in the Padlet. Also, towards the end of the week, I will add some scenarios with example answers on the test and quizzes tool of eFundi, like I did with homework activity for week 2. I'm going to do a homework activity week 4 or 5, and then those activities will help you prepare for assessment B as well as the exam. And you can use them throughout the coming weeks. Of course, also with Professor Molo, you will do some scenarios based on labor issues, scenarios based on learner discipline issues, and with Dr. Elof, you will do scenarios based on school safety issues. So you will have plenty practice on how to answer questions on with a scenario, but I will give you 28 different scenarios, and at least 10 of them will have a proper example answer for answering those scenarios. And then you can go to the homework activity, choose a few of the scenarios, do them on your own, individually, independently, so that you can get practice. If you struggle, please don't hesitate to reach out to me via WhatsApp so that I can support you. Okay, so let us start. I'm going to look at the scenario. There are certain issues that I saw there. Maybe you saw issues that are different from mine. Please just also then jump in and tell me what the issues are that you saw that I maybe have missed. There are multiple issues that we can deal with. So I'm going to start with human rights, because I see multiple human rights violations in this scenario. First of all, section 9, equality. There's an issue for me because the learners in that used alcohol were treated differently from the learner who used dagga, although both of them are intoxicating substances used during a school activity. In this case, the learner who used dagga relied on, in their argument, on their cultural and religious rights. However, those rights can be limited and are limited by the Schools Act and the regulations and the guidelines for code of conduct, all of which prohibit the use of intoxicating substances at school. So that's something you could have mentioned. You could have mentioned human dignity, section 10 of the Constitution. Also, Constitution cited correctly as the Constitution of the Republic of South Africa, 1996. Could have cited section 10, human dignity. The learners were humiliated and degraded in front of a lot of people, which might be violating their human dignity. You could look at section 12, specifically subsection 1, subsection E, the right to freedom and security of the person, which includes the right not to be treated or punished in a degrading, cruel, inhuman way. And you could argue that or punished. You could argue that the principal punished them in a humiliating manner, which then violated their rights in terms of section 12. You could rely on section 14 about privacy to say that learners have the right to privacy, which includes the right not to have their possessions seized, namely the alcohol. You must make that link. Principal search their bags, seize the alcohol, which might be a violation of their privacy. However, the right to privacy can be limited and is limited by section 8A of the Schools Act, which allows the school to do searches and seizures granted or only if specific procedures are followed. So long as the school principals stick to those procedures in section 8A of the Schools Act, it's not a violation of their privacy. However, the school principal did not follow the procedures, therefore it's a violation of their privacy. Okay, then you could also look at section 33, the right to just and fair administrative action. Search and seizure, disciplinary action, suspension, expulsion, all of those are administrative actions where we exercise our authority as the school over the learners. And in those exercise those instances where we exercise authority, we have to do it in a way that respects the learner's right to a fair and just administrative action. In this case, the principal did not follow the proper procedures, therefore violated Section 33 rights of the learners. You could refer to the learner's right to freedom of religion and culture, Sections 15, 30, and 31, and then also argue that those rights can be limited and is so limited in the Schools Act by prohibiting the use of dagga at school. Okay, I think those are, you could also cite Section 29 and talk to the right to education, because suspension and expulsion also does influence the right to education. However, again, the right to education can also be limited and is so limited by Section 9 of the South African Schools Act that allows us to suspend and or expel learners from school based on serious misconduct. Okay, so for me, that covers human rights. Then in the Schools Act, I would start with Section 1. Well, actually, let's start with the other sections and come back to Section 1 to help us define certain important concepts. Okay, so in the Schools Act, we have Section 8. If we want to start in Section 8, which deals with discipline, you could say that the school must have a code of conduct, and the code of conduct must outline what is serious misconduct and what steps will be taken against the learner if they are accused of that misconduct. You can also cite the procedures in the subsections of Section 8. Disciplinary proceedings refers to disciplinary hearings, and that the disciplinary hearing must be held. And that you have to obviously read together with Section 9, that also refers to the disciplinary proceedings. Also, if you read Section 8, you also read it together with the document Guidelines for a Code of Conduct for Learners that outlines for us what is serious misconduct in Section 11. It mentions conduct that endangers safety and violates the rights of others, possession, threat, or use of a dangerous weapon, possession, use, transmission, or visible evidence of narcotic or unauthorized drugs, alcohol, or intoxicants of any kind, fighting, assault, battery. So the learners were accused of serious misconduct. So you could have mentioned that, Section 11 of the Guidelines for a Code of Conduct, and then come back to Section 8 to say that there should be disciplinary proceedings, and then go back to the guidelines in Section 13, where the exact disciplinary proceeding process is described, to say that this is the process that the school must have followed. Okay, then let's come back to the Schools Act, random search and seizure and drug testing at schools. So in this case, you can talk about searching, you can talk about seizing the drug, the alcohol, and you can talk about even administering a test to see if the learners are indeed under the influence of alcohol. And then, of course, you need to, if you say drug, because it doesn't say alcohol, it says drug. So therefore, we have to go back to Section 1 to see, okay, so what is a drug? And then if we go to Section 1, where drug is defined, it says intoxicating or stupefying substance that has a psychological or physiological effect, a substance that has the effect contemplated in intoxicating or stupefying, and that is possessed contrary to the code of conduct of the school or any laws of the republic, a substance, the possessions of use. Okay, so it gives like a whole long definition. I'm not going to read everything, just to give you the idea. But you would use the definition of drug to get to the fact that alcohol is a drug, and then that the fact that alcohol is a drug means that we are allowed to do a search and to seize the alcohol from the learners. And then you need to also indicate that that procedure, that also has a specific, so you cannot just say the principal may search the learners, because there's a specific procedure. Yes, the school may search the learners, the principal or their delegate. But one of the issues there is that you can only search a learner of the same sex. The Act has not, unfortunately, in the billable. I thought it will be updated with gender diversity. It has not. So we only work with male and female in this Act for now, until we have a Bill Act again. Okay, so anyway, that's just a side note. Only same-sex search and seizure may take place. So we cannot just say, yes, the principal may. We need to bring in gender, say that we do not know the gender of the principal or the gender of, or the sex of the learners, and therefore we have to account for both and say, okay, well, so the principal may search if the learners are the same sex as they are. Otherwise, the principal has to delegate to another teacher or a deputy principal who are the same sex as the learners. Also, we need to say that the principal did not follow the correct procedures. The learners may not be searched in front of others. They must be searched in a private area. There must be another witness, and so on and so on. So all of that detail, you could also use all of that to say how the search may take place. Then if we come to section 9 of the Schools Act, suspension and expulsion, there you can cite several of the subsections. For example, subsection 2, which says that only the HOD may expel a learner. You can also cite subsection 1C that says the governing body may make a recommendation after a hearing, after finding the learners guilty of serious misconduct. The governing body may recommend expulsion to the head of department. And 1D, subsection 1D of section 9, the head of department must consider the recommendation and come back to the school with a decision within 14 days. Note the difference in wording. It is not the school that expels the learner with the permission or the approval of the HOD. It is the HOD that expels the learner. So there's also a difference in your interpretation there. And then section 10, prohibition of corporal punishment. You can say corporal punishment is abolished. No person may inflict or impose corporal punishment to the learner at school or during a school activity. And then again, go back to section 1 with the definition of corporal punishment to give evidence that indeed the fact that the principal poured saline into the mouths of the learners would constitute corporal punishment and therefore was unlawful action, and the principal may face a fine or imprisonment if they are found guilty of this offense. Okay, I'm trying to think if there's something I left out. Is there anything that you had that I did not touch on? Oh, of course, you could also refer to, you could ask the question, what steps may be taken against the principal, since the principal is guilty of multiple forms of misconduct in all violations, in which case you could then cite sections from the Employment of Educators Act in the disciplinary code, or you could even say that they can a criminal case can be made against the principal, in which case you could cite not education legislation, but criminal legislation. Okay, any questions? Anything you had that I did not mention or touch on, which you just want to check in whether it's relevant or not? If I don't see your hand, you can just open your mic and speak.
I have a question, ma'am.
Yeah. Please go ahead.
The learners who use Dagga for their religion, I want to know what, my question is, should the learners be suspended or expelled for using drugs, but then they say that their religion says that they have to? What should you do?
Okay. Yeah, so when there's a conflict between different rights, the rights are balanced out through limiting one or more of the rights. So we as individuals, as teachers, as school principals, we don't limit someone's rights. The law can limit someone's rights. So that's why I would say then, yes, the learner has the right to freedom of religion, which allows them to use Dagga. Also, but it's the same for alcohol. Yes, you have the right to use alcohol if you are 18 years or older. If you are younger than 18, you also don't even have that right, or you have the right, but the right is limited because of your age. And that limitation is somewhere in the law, in the Drug Abuse Act, to be precise. In this case, also the right to use, even if the learner is 18 or older, and it's within their right to use Dagga as part of their religious activities, That does not mean that we need to allow them 24/7 to perform those religious activities at school. I mean, we're not going to allow someone to pray or to smoke dacha or to do other rituals at school at any whim, at any time when they choose. There are specific rules that are attached to religious observances at school in terms of section 15, subsection 2 of the Constitution. And also, again, the right to use dacha as part of your religious practices or even do anything else that is in contrary to the school's code of conduct, which you might say, this is my culture or this is my religion, that right may be limited. Of course, the limitation of that right is, in this case, in the law. The law says you are not allowed intoxicating substances or to be under the influence of intoxicating substances at school or school activities. So that we read clearly in the Schools Act, as well as in the regulations for safety measures, as well as in the guidelines for code of conduct for learners. So we have 3 documents just within the education space that does not allow that at school. So which means the law already limits that right. The learner can do it at home or at any other place, but they cannot do it at school. Does that answer your question?
Okay, so in this case, then I have to cite both laws. The one that says the learner has the right to use the drugs for his religious activities, but also the school does not allow it, and then I cite those laws.
Yes, yes. Is to say that the right to use it as part of your religion is limited by the Schools Act and the guidelines and the regulations, to say that not at school. And of course, it's also limited by the learner's age. We don't know the age of the learner, but if the learner is under the age of 18, there's also a criminal law limitation on the use of intoxicating substances for underage people in South Africa.
Okay, so let's say the learner is above 18 years old, then I just say that the laws of the school says that you are not allowed to use drugs or any substance at school.
At school, yes, or even be in possession of.
Okay, okay.
Yeah. Any other questions? So you have asked for a step-by-step, I think, revise the videos of weeks 2 and 3, and also today's. Look at my responses to specific answers on Padlet, which I will continue throughout the week. And then, of course, also when I put the homework activity for week 4 up towards the end of the week on tests and quizzes, that will also help you, where I will give like an example of an essay. So I will give you a couple of essays to answer specific questions on scenarios. And I think that will also help you. If you are uncertain about where to find what law or what legislation to consult, remember you first need to have some basic knowledge. So study your chapters in your textbook, and on the basis of your basic knowledge, you will be able to identify easier. And also remember the long title of the Act and the objectives of the regulations or the norms and standards and so on. They also give us clues. Don't forget those. So if you go, for example, to the Schools Act and you read it and you see, okay, this is all about the school system, the organization, the governance and the funding of schools. Okay, no, I don't think I will find it there. Regulation, okay, this is all about disciplining learners. Yes, let me see, maybe I will find it here. So also the objectives and the long title of the Act will help you to identify which documents are relevant to you. But as you get to know the education law, which you should, it will be easier for you to identify. Okay, there is a question from Daneo. Please go ahead.
Afternoon. I hope.
Hi. I can hear you. Yes, you can go ahead.
Yes. I just wanted to ask, because we have to familiarize ourselves with the resources, and some of us don't really. I am still waiting for a textbook, and it's hard navigating this whole thing, because sometimes we do want to refrain from using AI, which is it doesn't really help us, because I'm referring to the message that you send on previously concerning AI. But what do we do then in the meantime when we do not have the resource that we need? And I feel like I'm falling like behind. Like now, I really wanted to engage in the lesson, but it is very hard. What do we do? What would you recommend to us in the meantime? Because of the copyrights also, we are not
Yeah.
allowed to ask for pictures from the chapters and all that.
Yeah. Okay, that's a fair question. I'm really every year we have the same issue, which is really problematic. I would prefer. I think that's also why the university said we are going to stop delivering books and just let everyone buy their own books, because then as soon as you register, you can buy your books and you don't have to wait 4 weeks for the registration date to finally pass before you can actually even begin to receive books. But in the meantime, if you have sent me your request, your proof of registration, and your little book icon, I would have sent you the two most important chapters for this first 4 weeks. So you would have that already. Also on the eFundi site, under the module information, where I give you additional reading or optional reading or something. I can't remember the heading precisely, but under the optional reading sections, I have listed multiple sources. They are in the library. Many of them are available as ebooks, so you can take them out, even electronically via the library website. Also, I have added links to some open sources. So there are some books that are available open source, no copyright issues there. You can also access those books and look for some of the content in that. Obviously, it's easier if you have the textbook, but that is some of the additional sources which for now you can consult to just help you. My note on the AI was when you answer questions, because some students will even as we do activities in class, instead of trying to do it in their own words, they would go to AI and they would bring the AI answer to the Padlet or to the chat or wherever we did that. And then the problem is that AI's answer is not aligned to the way you should structure your answer, firstly. Secondly, AI sometimes doesn't have the correct citation. And thirdly, almost never will AI include the correct sub and subsections. It will only keep the main section, which then will make your answer incomplete. So that's why I said don't use AI. And of course, also, if you use AI of course, you can use AI to help you learn. Absolutely use AI to help you learn. If that helps you, I would specifically recommend Notebook LM, where you upload something and you ask Notebook questions about it. It can make you flashcards. It can ask you questions. It can make you a diagram and all that, and a little video and an audio and so on. So that's really very helpful to use AI to learn, but don't use AI to do work for you when you need to answer a question. Answer the questions on your own. Try that independently, because when you write exam, in the end, it's only you alone and your brain, nothing else to help you. Does that make sense?
Yes, thank you very much.
Okay, you are welcome. Al Ndebele, you are welcome to ask your question.
Good evening, Doctor.
Good evening. How are you?
I'm good, thanks, and yourself?
Good, thank you.
I'm good.